Mr Bogle.
Lord, yes, I was going to take your lordship to briefly just to the case of John at tab 13.
Yep. Sorry, which?
Sorry, tab 13. Beg your pardon, it's tab 8.
Page 114.
Page 114. 114. Very briefly, that was a case in which M, it's actually Crown against M. John, appealed against convictions for rape, indecent assault, indecency with a child, and indecent photographs. He suffered from a serious impairment in his short-term memory known as anterograde amnesia, which the defence argued rendered him incapable of following the proceedings and giving evidence in his own defence, and therefore unfit to stand trial. He contended the judge had misdirected the jury on the issue of fitness to plead by setting the test too low, and the judge had wrongly admitted transcripts of police interviews more than a year earlier, since at that time his mental health had not deteriorated to the extent which it had by the date of trial. The court dismissed the appeal and said the applicable test was whether the defendant was of sufficient intellect to comprehend the course of proceedings on the trial so as to make a proper defence, Pritchard again. Mere fact that a defendant might not be capable of acting in his best interest during trial was not sufficient to warrant a finding of disability, and a jury should not be directed that the issue was whether he was able properly to instruct counsel or to give proper evidence. A loss of memory was not necessarily sufficient to render an accused unfit to plead. Merely because the defendant was highly abnormal did not mean that he was incapable of doing the things set out in Pritchard. Furthermore, the evidence of 3 psychiatrists tended to show that his mental state had in fact improved since the interviews were carried out. Potentially, therefore, they had probative value on the issue of M's fitness to plead and had not been wrongly admitted. And at page 114, the first page, Lord Justice Keane said, the principal issue in appeal concerns the test to be applied as a matter of law in determining whether an accused is fit to plead to charges against him. And he went on to say, at page 116, and that's a paragraph 20, the third sentence, he directed them that in order to be fit to stand trial at all, a defendant must be capable of doing 6 things, and those are the 6 things that we have seen in other cases. Understanding charges, deciding whether to plead, exercising right to challenge jurors, instructing solicitors, following the course of the proceedings, giving evidence in his own defence. And the judge gave an explanation to the jury in each case of what it meant. When it came to the item instructing his solicitors and counsel, the judge began by saying, this is the paragraph 21, this means that the defendant must be able to convey intelligibly to his lawyers the case which he wishes them to advance on his behalf, and the matters which he wishes them to put forward in his defence. It involves being able, A, to understand the lawyer's questions, B, to apply his mind to answering them, C, to convey intelligibly to the lawyers the answers which he wishes to give. It is not necessary that his instructions should be plausible or believable or reliable, nor is it necessary that he should be able to see they are implausible or unbelievable or unreliable. Many defendants put forward cases and explanations which are any of those 3. The whole purpose of the trial process is to determine which parts of the evidence are reliable and which are not. Then he went on at paragraph 22, as to item 5 on the list, following the course of proceedings, the judge's direction included this passage. This means that the defendant must be able to, A, understand what is said by the witness and by counsel in their speeches to the jury, and B, to communicate intelligibly to his lawyers any comment which he may wish to make on anything that is said by the witnesses or counsel. Few defendants will be able to remember at the end of court session all the points that have been occurred to them, or may have occurred to them about what has been said. It is therefore quite normal for the defendant to be provided with pencil and paper so he can jot down notes and pass them to his lawyers, either as and when he writes them or at the end of the session. There is also no reason why the defendant's solicitor's representative should not be permitted to sit beside him in court to help him. And a little later, under the same heading, he said it's not necessary the defendant's comments on the evidence and counsel's speeches should be valid or helpful to his lawyers or helpful to his case. it often happens that a defendant fails to see what is or is not a good point to make in his defence. The important thing is that he should be able to make whatever comments he wishes. And as to item 6, giving evidence in his own defence, the direction included the following. This means the defendant must be able to understand the questions he has asked in the witness box, to apply his mind to answering them, to convey intelligibly to the jury the answers he wishes to give. It's not necessary his answers should be plausible or believable or reliable, nor is it necessary he should be able to see that they are implausible, believable or reliable. Many defendants and other witnesses give evidence which is either in whole or in parts, none of those things. The whole purpose of the trial process is to determine what parts of the evidence are reliable and what not. In short, repetition of what he said before. He's entitled to say he has no recollection of those events or indeed of anything that happened during the relevant period. And in my submission, that set of criteria and the explanation thereof must, for the same reasons, apply equally to civil contempt proceedings. And over the page 118, paragraph 28, the original then sets out the original formulation of the test in Pritchard, and then goes on to explain this was endorsed in Hodler and in Robertson. And at paragraph 30, he says this court there held that the mere fact that the defendant may not be capable of acting in his best interest during the trial is not sufficient to warrant a finding of disability, and that a jury should not be directed on the issue as whether he is able properly to instruct counsel or to give proper evidence. Again, this court in Berry, presided over by Lord Justice Lane, as he then was, followed Pritchard and Robertson. And the fact that a defendant was highly abnormal did not mean he was incapable of doing those things set out in Pritchard. Those authorities clearly established the law on this topic. When we consider the judge's directions in the present case, in the light of those authorities, we find no deficiency in them. Indeed, this court regards them as admirable directions. They do not set the test of fitness to plead at too low a level. So, in short, the test applied by Pritchard must be considered by the court and, of course, by the medical expert, who himself will lay down the evidence that the court will then consider as to whether or not the Pritchard test has been met. And it's by no means, it requires careful deliberation by a court. In my submission, that implies mutatis mutandis to civil contempt proceedings. Now, what is the procedure? So, dealing briefly with the procedure adopted in criminal cases, insofar as it's important for your lordship, it is provided by statute that the question of fitness to be tried shall be determined as soon as it arises. And the same statute provides as follows: that the court shall not make a determination as to fitness to plead except on the written or oral evidence of 2 or more registered medical practitioners, at least one of whom is duly approved.
So this is section
that is
4.6 of the Criminal Procedure and Sanity Act.
That's the one, and that's at tab 1 of the bundle on page 5 thereof, subsections 4 and 6. Subsection 4 reads, subject to subsections 2 and 3 above, the question of fitness to be tried shall be determined as soon as it arises. Subsection 6, the court shall not make a determination under subsection 5 above except on the written or oral evidence of 2 or more registered medical practitioners, at least one of whom is duly approved.
Just to avoid misunderstanding, I take it you're not contending that this Act is applicable to the present case?
That is not applicable to the present case.
I assume you're not contending that the 1984 Act...
No, I'm not.
Sorry, 1964 Act is applicable to the present case?
No, my lord. I'm again, raising it by way of analogy. What I'm saying is that this is clearly intended only for criminal proceedings. There are, I fully accept and have accepted, differences between criminal and proceedings and civil contempt proceedings, but I raise them because, once again, in relation to the issue of fairness of trial, and indeed of the ability of the court to be able to proper determination about the fitness to plead or indeed mental capacity of the party concerned. In criminal proceedings, it's got to be dealt with as soon as it arises, and in my submission, the same should apply in civil contempt proceedings. It shouldn't simply be.
Well, I understand that submission, but can you help me on this? As you were just reciting, one of the provisions of the criminal statute says the court shall not make any determination except upon the evidence of 2 or more registered medical practitioners, at least one of whom is duly approved. Now, is it your contention that that applies in the present context?
No, my lord.
Right.
No, it's one of those.
So what do we? How do we know which bits of the 1964 Act are valuable by analogy when you accept that other parts don't apply?
Well, the same can be said of those other differences between civil contempt proceedings and criminal proceedings. I gave one example, the issue of whether hearsay is admissible or not. It's clearly not admissible in criminal proceedings. Clearly is admissible, because the court says so, in civil contempt proceedings. So it's a matter for this court to decide where the boundaries are. All I can do is urge that there is an analogy with criminal proceedings. Exactly how far that analogy goes is a matter for the court. But in my submission, relying on authorities or cases like Jelson, a certain level of strictness ought to be applied. And what I'm saying here is the level of strictness wasn't applied by Mr Justice Leech in his decision, and that is why he made an error of law. What I'm not saying is that a statute that obviously applies to criminal proceedings must therefore apply to civil contempt proceedings.
Can I follow the point, but can I just pursue it a moment longer? So in terms of section 4.6, at least one of the medical practitioners has to be duly approved. And I see in section 8, subsection 2, that explains that duly approved means approved for the purposes of section 12 of the Mental Health Act, and so on, as having special experience in the diagnosis or treatment of mental disorder. I have a vague recollection that one of the reports had something similar attached to it, but I can't remember which one it would have been. Or maybe I'm wrong.
Yes, one moment, my lord, if I may. Yes, I can't remember it off the top of my head, my lord, I'm afraid.
No.
I should just add that Dr. Gupta is duly approved.
My lord, I might add as well, if only because I have the page open in front of me.
Yes.
Dr. Rajpal is duly approved.
So they're both duly approved.
Respondents Supplemental Bundle, page 319.
Yeah.
Is the appendix to his CV, which my lord may have had in mind.
I think that probably is what I had in mind. Yeah.
There we are. And so, so in my submission, the important point there is that applying the analogy with some strictness, Herb, Jelson, it's in my submission, there's a degree of obviousness in stating that it ought, as soon as it's been raised by the party's legal representatives, if no one else, that the court should then embark upon an investigation as to the defendant's mental capacity and fitness to plead. And if in order to do that, and this is again going back to the gravamen of my submissions at the beginning, in order to do that, expert evidence is needed, and it must be expert evidence that isn't obtained on 10 days' notice, is necessarily thin as a result, and is rejected as a result of being thin because, in part, it was only provided on 10 days' notice. What is required is full and proper medical evidence, so that the court can then arrive at a fair and just decision, can investigate the facts more as fully as is needed in proceedings that are quasi-criminal, and arrive at a fit and proper conclusion.
Just on that point, can you help my memory, because I should know the answer to this, and I apologise I don't. But on receipt of Gupta 2, the matter, as you say, came before the judge a couple of days later. Did you apply to the judge for an adjournment, saying, we've not had enough time, we need more time in order to substantiate this evidence more fully?
Yes, I did.
Right. And was that refused?
Yes, it was refused.
And do you have an appeal against the refusal of the adjournment?
Well, it's, in my submission, wrapped up with this appeal, in effect.
Well, no, it's not. They're two different things.
They are
You
different
have an
things.
appeal against the ultimate decision, but at the moment I'm not hearing you've got an appeal against the refusal of the adjournment.
Well, if your lordship is of that view, then certainly I would submit and ask the court to permit an amendment to the grounds of appeal to include an appeal against that adjournment. But my primary submission will be that it is, although I apprehend it doesn't meet with your lordship's approval, subsumed in ground one of our grounds. But if I'm wrong about that, then I would seek leave to make the necessary amendment to add it to the grounds of appeal.
Okay.
But that is the...
Can I just clarify something? If we go to the sanction judgment, paragraph 10,
One moment, my lord.
this is page 99 of the core bundle, I think. Uh,
91 of the core.
sorry, 99 of the core bundle, paragraph 10, which I think is the sanction judgment.
Paragraph 10, yes, my lord.
There, the judge explains that you had invited the court to take one of three courses. The second of which was to adjourn the question of sanction. The third was to adjourn the question of sanction and direct the service of expert evidence. Now, when you were telling my lord a moment ago that there had been an application to adjourn, was that application different from that application?
No, that's the application I made.
Yes, that's
I'm sorry if I've caused any confusion. So I invited the court to take those three, one or all of those courses.
yes, I see.
In declining to accede to that application, his declination is subsumed into his overall judgment, and that is why I has tentatively put the submission that it's included in my...
Yeah, you see, maybe we're at cross purposes here, and I'm grateful to my Lord Justice Newey for pointing out the application that you undoubtedly did make, and against which you undoubtedly do have an appeal. But the question I was putting to you was a slightly different one. Because and it may be I misunderstood what you were saying. I thought you were making a submission to the effect that your client was in a difficult position because she had only had a short period of time in which to obtain what transpired to be Gupta 2, and that had been compounded by the fact that Gupta 2 was only received a couple of days before the hearing. And the question that I was asking arising out of that understanding was, well, did you ask for an adjournment of the hearing that took place? In other words, not the application that you made at that hearing, but an application to put back that hearing itself.
Yes. Yes. I made that application on the first time the matter came before. The court originally intended to hand down judgment
But that was granted, wasn't it? I mean, he gave you an adjournment.
Yes, he did.
And he gave you more time.
That's right, he did.
But you seem to be submitting that despite the adjournment that you were given and the more time you were given, it was still not enough.
Understood.
And so my question is, did you ask for a second adjournment?
Exactly. One moment, my lord. There's some confusion of recollection of exactly what happened, but in essence, I think the answer is this, my lord. Until the committal until the sanction judgment was given, we weren't to know that the report produced by Dr. Gupta was going to be deemed unsatisfactory by the court because of its shortness and its terseness.
Right.
Not unreasonable
I
assumption.
understand that submission, but it brings me back to where I thought we were, namely that having received Gupta 2,
Yes.
you chose to go ahead on the basis of that evidence, and you say that evidence was enough, and it should have led the judge to make one of the orders for which you contended.
And paragraph 10, yes.
Correct.
That's it.
You didn't choose instead to ask for an adjournment, which
Not
is
at that
why there's no appeal against any such reviews.
Yes, exactly, my lord.
Yeah.
I'm sorry.
I think we're all clear now.
I'm sorry if I didn't understand your lordship in the first place.
My lord,
There was.
I keep popping up with small points, which I try not to do, but my lord might also wish to look at paragraph 6 and 7 of the sanctions judgment, which refer to an application by Ms. Khan to vacate the sanction.
Yeah, well, that was the point which Mr. Bogle was telling us about earlier, where there was an extension of time for serving further evidence.
Well, my lord, there were several. So, as I understood the exchange between your lordship and Mr. Bogle, there was reference to the application opposed by the SRA but granted by the judge on the 14th of February, not to deal with sanction on the 14th of February as he had originally intended to do, but instead to grant time for further expert evidence. That's set out in paragraph 6 of the sanction judgment.
Yeah.
Paragraph 7, which is the point I just wanted to make sure we were all clear on, is that there were other applications made in the meantime, and the judge, as part of that, there was an application on paper for the hearing listed on the 8th of March to be vacated. That was actually, in fact, to answer the detail of my lord's question, before the receipt of Gupta 2, but in anticipation of the fact that it wasn't yet available.
That's correct, my lord.
Yeah, yes, indeed. But what then happened was the judge extended time for the expert evidence until the 6th of March, and the evidence was served by that time.
Yes, my lord. And the other point, of course, is that there is no appeal against their refusal to vacate as at prior to the receipt of
Indeed.
Gupta 2.
For the reasons I said, my lord, at that stage, it seemed as if Dr. Gupta's report, which was pretty clear and pretty decisive in its own language, would be sufficient.
And that's your point.
Yeah.
You say Gupta 2 is good enough.
Yeah, precisely. And as it turned out, it wasn't. What it should have been is enough for the court to say, all right, I'm not satisfied with Gupta 2. Dr. Gupta, go away, make another report, come back and be cross-examined.
Sure.
That's the point.
Yeah, well, that point is very clearly articulated. Thanks.
And if the experts disagree, the court can arrange for a contested fitness to plead hearing or capacity hearing, where the experts can be examined and a decision then reached by the judge. And it's submitted that the same or similar must apply in contempt proceedings as in criminal proceedings, again for the same reason, because the ability of the defendant to participate effectively in proceedings is fundamental to a fair trial. I suppose there is also the consideration of a defendant's ability to participate in proceedings if compromised or vitiated, may of course also raise the issue of abuse of process in continuing the proceedings in any event. And I've drawn your lordship's attention to the what seem to be the principal authorities, at least in the criminal jurisdiction, where a defendant is under a disability and proceedings have to be stayed as an abuse of process. But that's something I ought to raise and do therefore raise. Now, how does this compare with civil contempt proceedings? Without labouring on points that I've already made, obviously the starting point is that it's quasi-criminal. The allegations are tantamount to charges and must be proven to the criminal standard beyond reasonable doubt. And I pause there to say that at the very least there must have been some doubt raised by Gupta II, if nothing else, at least in relation to the fitness to plead, and I would submit ought to have raised doubts in relation to capacity as well. And any doubt ought to be resolved, of course, in the defendant's favour. And that is a difference, a very distinct difference between civil contempt proceedings and ordinary civil proceedings.
Actually, can I just be clear about that? So on the fitness to plead basis, you say that if there's any reasonable doubt, well, if there's any reasonable doubt, what?
Well, any reasonable doubt must be resolved, obviously, in the defendant's favour. Reasonable.
It's not obvious that is the case in criminal proceedings. What you showed us earlier was that in criminal proceedings, the question of fitness to plead may be raised by the prosecution or may be raised by the defence. If raised by the prosecution, they have to establish it beyond reasonable doubt. And that's because it can impact on the liberty of the defendant, because a finding of unfitness may lead to a hospital order.
Yes.
If raised by the defendant, so it's a defence to the criminal charge, but if raised by the defendant bears the burden on the balance of probabilities.
That's true, my lord. That's true. And so as regards capacity of fitness to plead, from the once raised by the defendant, yes, it need only be on the balance of probabilities. But
so just to be clear,
but when
it's then for the defendant to prove on the balance of probabilities unfitness to plead, or you would say lack of capacity.
yes, if raised by the defendant must prove it on the balance of probabilities. Raised by the prosecution, but the prosecution must prove it beyond reasonable doubt. But the point I'm making is that not just in relation to mental capacity or fitness to plead, but as to the proceedings as a whole, the judge has got to consider all doubts that might be reasonably construed in favour of the defendant.
But that's doubts in relation to the substantive questions of actus reus, mens rea, liability, and so on. But I think the question of capacity or fitness is a different order question. It's a question of how do you procedurally try the charges, not what needs to be proved on the charges. And I think, as I understand it at the moment, if it's a question of fitness, by analogy with the criminal position, if a defendant raises fitness, it's for the defendant to establish that on a balance of probabilities. And I apprehend the same would be true in a question of capacity, because under the Mental Capacity Act, everybody's presumed to have capacity unless the contrary is shown. Is that not right?
Yes.
Yes. So I don't, for myself, think that the necessity for the court to be satisfied of the substantive charges beyond reasonable doubt actually affects this question.
Indeed, my lord. And if mutatis, I mean, in parallel with the submissions I've already made, ceteris paribus, if I'm going to argue that, by analogy, the criminal procedural rules should be carried across to the civil contempt rules. I can't have my cake and eat it, I suppose, and say, but not that it must be proven only beyond reasonable doubt. That I accept what your lordship is saying there. It's once again, it's a matter for the court as to how far the criminal analogy is to be taken. But I suppose I must accept that if on something as fundamental as standard of proof, then it ought to apply to charges mutandis in the same way as the criminal proceedings. So I accept what your lordship is saying. But nonetheless, it's the fact that the charges themselves must be proved to the criminal standard is what makes the proceedings qualitatively different from ordinary civil proceedings, particularly as regards what is a fair trial. And your lordship has already seen and indeed drawn your lordship's own attention to the case of Deripaska, where Lady Justice Khan makes her comment to that effect in relation to Article 6. Now, what it also means then, if that is going to be carried across to the civil contempt proceedings, is that the respondent only needs to show on the balance of probabilities, precisely the point we've just been making, that he or she is not fit to plead to the charges and stand trial, or indeed understand the charges, be able to give evidence, and so on, instruct legal representatives. That being the case, then the amount of evidence required to prove that is going to be rather less than would be required at the criminal standard. And once again, therefore, Gupta 2 should have been a red flag to require the judge to, if not to rely on Gupta 2, which he clearly was not willing to do, but then at least to give Gupta another chance to put his case more fully. It's understandable that the judge wanted an attenuated timetable of, in this case, only 10 days to provide the additional evidence. But once the evidence arrives, then the position is radically changed. And clearly, a new timetable must be set for full and proper evidence, medical evidence, to be provided to the court so that the court can make a full and proper determination in relation to fitness. And all that's required of the defendant is simply to show that this is necessary to the civil standard, because the civil standard is all that's required to prove that he or she is not fit to plead or to have capacity. And if any of those criteria that are set out in Pritchard and related cases are missing in a criminal trial, any one of them, and the defendant is thereby rendered unfit to plead or stand trial, then he can't stand trial. And the trial would be unfair if it were to proceed, and if the defendant were compelled to stand trial, as in effect happened in this case. Then, since this goes, in my submission, directly to the issue of fairness under Article 6, then the same, in my submission, must apply to civil contempt proceedings. In addition, although I apprehend that criminal contempt proceedings are not necessarily criminal proceedings, I'm aware of that, if they are brought in before a criminal judge, my understanding, and be corrected if I'm wrong, is that they are criminal proceedings. Now, the criminal regime for dealing with fitness to plead would, in those circumstances, in my submission, apply to proceedings for criminal contempt before a criminal judge. And yet, in substance, there's no real difference between those proceedings and criminal contempt proceedings before a civil judge, or indeed civil contempt proceedings before a civil judge. So why, I would ask, should the regime apply to criminal contempt proceedings before a criminal judge, but not to civil contempt proceedings, or indeed criminal contempt proceedings before a civil judge? In my submission, there's no logical reason why it should be, a distinction should be drawn. And what is required for a fair trial and for the benefit of the defendant in the criminal proceedings, criminal contempt proceedings before a criminal judge, in my submission, there's no logical reason why it shouldn't also apply to criminal proceedings before a civil judge, or for that matter, civil contempt proceedings before a civil judge. He will face the same disability in the civil contempt proceedings as he will in the criminal proceedings, i.e. he will be unable to make a proper defence. And in my submission, that goes to the very heart of whether the trial is Article 6 compliant, no matter which court the proceedings are brought in. The court could therefore deal with the matter as I invited the court to do, by giving directions for a hearing on fitness to plead and for filing of further evidence of cross-examination if necessary, or indeed for the SRA to provide its own expert, or to have access to Dr. Gupta. And only after following such a proper procedure, analogous with criminal proceedings, could the court realistically and fairly arrive at a proper decision as to fitness and capacity. And as things stand, the court has no expert evidence directly touching upon the issue of the appellant's mental capacity. And yet the court nevertheless determined the issue and made a judgment thereon without such expert evidence. I'm not saying the court can't do that. I'm saying that it does go directly to the issue of fairness and to a fair trial. And in my submission, in these circumstances, was a clear error of law that must be rectified by this court. And it's clear in any event that a court needs to consider the issue of fitness to plead, even if only in relation to the issue of capacity to litigate pursuant to CPR 21.3. And that requires that the litigant's mental state is fully and properly investigated. And indeed, the learned judge effectively admitted as much himself at paragraph 14 of the confidential schedule by saying that if he had accepted Gupta's evidence, it would have been a powerful argument to halt the proceedings. All right, fine. But if you don't accept Gupta 2, let's have Gupta 3, and that might provide the very powerful argument that the judge himself admitted would be sufficient to halt the proceedings. Furthermore, the CPR highlights the duty of the courts to manage cases actively, and this duty must include proactively considering issues related to a person's capacity or fitness to participate in proceedings. And whether that's done under the rubric of CPR 21 or by analogy with fitness to plead in criminal proceedings, in my submission makes no difference to the duty of the court to act fairly and justly, and to do so by first examining the fitness and capacity of the party concerned through a hearing for that purpose, and not merely attempting to do so, in effect, summarily, as the court, in my submission, came close to doing in the sanction judgment. Anything less must be unfair, unjust, and prejudicial. Now, in the case of Tainaz against Wandsworth London Borough Council, 2002 EWCA Civil 1040, this court held that the Employment Appeal Tribunal had been entitled to conclude that in refusing to accept the validity of a medical certificate submitted by the claimant in support of an adjournment request, the Employment Tribunal had erred in the exercise of its discretion, and this court held that in exercising its discretion, a tribunal should allow applicants the opportunity to show a legitimate reason for non-attendance on medical grounds. And I say by analogy, even though the party is present, the party is unable to participate by reason of mental defect, then there is a clear analogy. In Tainaz, I'll come to that in just a moment, there was an adjournment for medical reasons, non-attendance, and as I say, there's an analogy in a situation where a party, despite being in physical attendance, is not able to participate due to lack of fitness or capacity, and so seeks an adjournment for that issue to be resolved. And in those circumstances, in my submission, an adjournment is doubly required, since if capacity is lacking, pursuant to CPR 21.3 sub and 4, which we saw earlier in my submissions, that requires that proceedings cease immediately until after a litigation friend is appointed. And in criminal proceedings, if the defendant is unfit to plead, then the trial against him cannot proceed further in any event, save, as we've seen, to the extent that an actus reus trial could be heard. So, tab 7 is where Tainaz can be found, and that is at page 101 of the bundle, of the authorities bundle. And That was a case where the applicant presented an originating application, as they were then called, complaining of racial discrimination and unfair dismissal by the respondent council, Wandsworth London Borough Council. A week before the date set for the hearing, the applicant's representative wrote to the tribunal seeking an adjournment, enclosing a medical certificate which stated that due to severe stress, the applicant had been advised to stay away from work for 2 weeks and not attend court. Adjournment was refused. At the hearing, the application for adjournment was renewed. The employment tribunal found the application had, quote, chosen not to attend the tribunal in order to substantiate his contention that he's not fit to attend, and that his absence reinforced their, quote, suspicion, unquote. The tribunal refused the adjournment, went on to deal with and dismiss the applicant's complaints. The Employment Appeal Tribunal allowed an appeal by the applicant against the tribunal's refusal to grant an adjournment and remitted the matter for rehearing. On the council's appeal, that appeal of the council was dismissed. And the court said where the consequences of the refusal of adjournment were severe, such as where it would lead to the dismissal of the proceedings, the tribunal had to be particularly careful not to cause an injustice to the party seeking an adjournment. And if I take your lordship to paragraph 21 and 22, which are at page 108 and page 109, respectively, Lord Justice Peter Jackson said as follows. I think it's his judgment.
I think it's Lord Justice Peter Gibson, not Lord Justice Peter Jackson.
Yes, it's Peter Gibson. A litigant whose presence is needed for a fair trial of a case, but who is unable to be present through no fault of his own, will usually have to be granted an adjournment, however inconvenient it may be to the tribunal or court and to the other parties. That litigant's right to a fair trial under Article 6 demands nothing less. The tribunal or court is entitled to be satisfied that the inability of the litigant to be present is genuine, and the onus is on the applicant for an adjournment to prove the need for such an adjournment. I might add, on the balance of probabilities. If there is some evidence that a litigant is unfit to attend, in particular if there is evidence that on medical grounds the litigant has been advised by a qualified person not to attend, qualified person presumably meaning a doctor, but the tribunal or court has doubts as to whether the evidence is genuine or sufficient, the tribunal or court has a discretion whether or not to give a direction such as would enable the doubts to be resolved. And of course we're talking here not about contempt proceedings, but about ordinary civil proceedings. Thus, one possibility is to direct that further evidence be provided promptly. Another is that the party seeking the adjournment should be invited to authorise the legal representatives for the other side to have access to the doctor, giving the advice in question. The advocates on both sides can do their part in assisting the tribunal faced with such a problem to achieve a just result. I do not say that a tribunal or court necessarily makes any error of law in not taking such steps. Again, in civil proceedings, yes. In civil contempt proceedings, it would be an error in my submission. All must depend on the particular circumstances of the case. I make these comments in recognition of the fact that applications for an adjournment on the basis of a medical certificate present difficult problems requiring practical solutions if justice is to be done or achieved. Now, this was, as I say, in relation to an ordinary civil case of employment, not civil contempt proceedings where the liberty of the subject is at stake. Well, Justice Peter Gibson, with whom the other judges agreed, pointed to the obvious course where any doubt or scepticism about the adjournment arose of directing that further evidence be promptly obtained, or the opposing side be given access to the doctor in question, so presumably to produce a supplementary report, or indeed the court might call the doctor concerned to be cross-examined. That's in an ordinary case, civil case. Now, these options, as we've seen just a moment ago, were presented to the judge in the present case on the 8th of March, with a view to the experts, or experts, if there be more than one, producing further and fuller evidence, and if necessary, being cross-examined as to fitness and capacity. Now, none of the options were taken up by the court, which decided to deal with the issue effectively, summarily, and in my submission, therefore, wrongly. Now, if that were wrong in an ordinary civil case, a fortiori, it must be wrong in a quasi-criminal matter such as civil contempt. In the more recent case of Bilter, UK Limited in liquidation against Tradition Financial Services Limited, 2021 EWCA Civil 221, this court identified the principles to be applied when deciding whether to adjourn a trial because of the illness of a party or important witness. And the applicable test was whether the refusal would lead to an unfair trial. Once again, it's the issue of an unfair trial. And there was no difference in weight to be given to an application to adjourn based on a party's own unavailability or that of a witness, such as an expert witness. And it was said there was considerable force in the suggestion that the court should have regard to fairness in relation not only to the parties, but to those caught up in the court's process, including witnesses, particularly where the outcome had consequences for them. So if we have a look at tab 19.
This is page 428.
Thank you, my lord. Case of Bilter. That was a case where the court identified the principles to be applied when deciding whether to adjourn a trial because of the illness of a party or important witness. The applicable test was whether the refusal of an adjournment would lead to an unfair trial, and there was no difference in weight to be given to an application to adjourn based on the party's own availability or that of the witness. The defendant appealed the refusal of the application to adjourn, even though this was a trial of VAT fraud proceedings in which he was accused of dishonest assistance. The claimants were companies in liquidation, alleged to be engaged in fraudulent trading. The defendant was a broker accused of assisting them in their breaches of duty. The claims alleged dishonesty against a number of the defendant's employees, including a manager, M. The claimants considered the defendant vicariously liable for that dishonesty. The defendant's dishonesty, the defendant denied dishonesty and indicated his intention to call witnesses, including M, to give oral evidence at the trial, which was listed for January 2021. In late December 2020, it came to light that the M's prognosis had improved and she was likely to have recovered sufficiently to give oral evidence on October 2021. On the 6th of January 2021, the defendant applied to adjourn the trial to allow for M's attendance, supported by her statement explaining her desire to vindicate herself, and the judge refused the application. Relying on Solanke, and we'll come to Solanke in a moment, against Intercity Telecom Limited, 2018 EWCA Civil 101, the defendant submitted that the judge had failed to ask himself whether a trial in M's absence would be fair and should have adjourned on the basis that it would not be. Claimant submitted that Solanke was dealing with an application to adjourn based on the party's own unavailability, not that of a witness, and that there was a significant difference between the two, and the appeal was allowed. And if we go to page 434, paragraph 30, the court being my lord here present, we see the following. In those circumstances, we were taken to a number of authorities dating back to long before the introduction of the CPR and received much more extensive submissions on law than it appears the judge did. I consider the authorities below, but it may be helpful if I indicate my conclusions on the relevant principles at the outset. These are that Mr. Scory is right that the guiding principle in an application to adjourn of this type is whether, if the trial goes ahead, it will be fair in all the circumstances. That the assessment of what is fair is fact-sensitive and not one to be judged by the mechanistic application of a particular checklist. That although the inability of a party himself to attend trial through illness will almost always be a highly material consideration, it's artificial to seek to draw a sharp distinction between that case and that of a witness. And at the top of page 435, paragraph 32, referring to the case of Dick against Pillar, 1943, first volume of the King's Bench division cases, 497, the court cites Lord Justice Scott at page 499 of that authority, saying the defence evidence was therefore material and perhaps critically important if the issues raised were really to be tried on the merits, or nobody else could give his evidence. And then on page 436, paragraph 36, there's reference to the case of Green against Northern General Transport Company Limited in 1970, volume 115 of the Solicitors
Sorry,
Journal.
what do we get out of this? Because Lord Justice Nugee stated what he got out of these authorities in the passage to which you took us. You know, there's an awful lot of authorities that are surveyed here, but the conclusion is clear. So why do we need to go through each and every one?
We don't. I'm simply drawing court's attention to where it can be found. And so I shan't trouble your lordship any further with that.
One thing I'm not clear of, probably because I haven't read it carefully enough, was there dispute about the medical issue here?
No, my recollection is the medical evidence was compelling and no issue was taken. The substantive argument in this court was that it made all the difference, but it wasn't the party who was unable to attend through illness, it was a witness. And as you referred to, I said that you can't draw a sharp distinction. It all depends on how crucial the witness is.
Indeed.
And if the witness is absolutely crucial, which she was in that case, then it can be unfair to go ahead without her.
Indeed.
But the medical evidence was recent, compelling and unchallenged.
But the principle that I'm drawing from your lordship's case is that if the witness is crucial, is important, is vital, it will be unfair to exclude that witness's evidence. And in this case, half, as it were, of, or at least Gupta 2, if it's inadequate, effectively means that Gupta 3, if we can call it that, evidence that was required to fulfill all the requirements that the judge required from medical evidence before he could make that proper, or at least in order to be convinced that that there was an issue of capacity or fitness, hadn't been provided, needed to be provided, and an adjournment was required in order to provide it. That's the principle I'm drawing from the case, not whether the medical evidence in that case was adequate or not. If your lordship follows my drift. So again, I say once again, the analogy may be drawn with a party who is in attendance but not able to participate by reason of lack of capacity and requires an adjournment for that issue to be clarified and determined. And once again, the issue should be dealt with as soon as it arises. One also ought to remember that in this particular case, time would have been required because permission was needed under the party's legal aid order before another medical report could be commissioned. It was something that couldn't be done in a very short time period. And indeed, to some extent, my lord, the difficulty was further compounded by the fact that permission for an earlier medical report had been expressly declined in the first contempt proceedings. So that, as I say, for the reasons set out above, the appellant's legal representatives were in a kind of limbo, in that they were obliged to take instructions, even if they might be faced with a client who was not fully fit to give instructions. Medical evidence at a later stage might have and might still show that. Accordingly, the issue of fitness and capacity should have been properly and fully dealt with as soon as it arose, so as not to put the legal representatives in that difficult position. Well, in a sense it was dealt with, but what I'm saying is dealt with in a way that wasn't the proper way to deal with it. And so failure to do so was therefore bound to be prejudicial to the appellant. She and her advisers cannot be criticised since they had raised the issue in the first contempt proceedings long before, and raised it again in these proceedings, and Dr. Gupta made it clear in Gupta 1 that he needed to carry out further assessment. So in those premises, the learned judge was further wrong in law to find that the test did not apply to contempt proceedings, or at least something analogous thereto. The learned judge when we say in the grounds that the learned judge failed to apply properly to apply the test for fitness to plead, whether under Pritchard or the similar cases, or in a similar by analogy, or indeed at all, in that there was no proper analysis of the six criteria set out therein. We're also not excluding that there wasn't a proper analysis on any tests set out in Section 3.1 of the Mental Capacity Act. So, in effect, the judge had no regard to his positive judicial duty to investigate issues relating to fitness to plead and stand trial. In fact, he effectively begged the question at issue, namely that of fitness to plead and capacity, by assuming that the appellant's participation, such as it was, and may well be that any future medical report says there wasn't really any, meant she was fit and incapacitated, when, in my submission, no such conclusion could rationally be reached without that further medical evidence. Now, I'll just make a few more points, if I may. If I can draw you... the issue of capacity was dealt with by the judge when he dealt with the status application at paragraphs 25 to 34 of the sanction judgment at pages 108 to 110 of the core. And as I mentioned before, at paragraph 30, subparagraph 2 of the confidential schedule, when he said that there was overwhelming evidence that the appellant had capacity. And he went through, in the confidential schedule, 8 strands of reasoning as to why he objected to Dr. Gupta's conclusions and evidence. And just dealing with those, if I may, briefly, even though what I say is that Gupta 2, if inadequate, should have been rectified by a further medical report, and that is, and remains my primary submission. Nonetheless, it's appropriate to consider those 8 strands of reasoning. He said in the first instance that no instructions to consider fitness to plead were given to Dr. Gupta, and the reasons for addressing the Pritchard test were not explained. Well, it's correct that the issue of fitness to plead is not expressly mentioned in Gupta's summary of his instructions at paragraph 3 of his report. However, it was implicit in my submission in what he was asked to do. The instructions at 3 sub 4, little Roman 4, invited Dr. Gupta to consider the extent to which the appellant understands and can process the current proceedings. This would reasonably have led a consultant psychiatrist with experience of giving expert evidence in criminal proceedings, such as Dr. Gupta, to consider the issue of fitness and the Pritchard test. It's not surprising, therefore, that that's what he did. Moreover, summarising his instructions is what he did in that paragraph, rather than setting out seriatim every point of them. And that's apparent from his particular style of underlining the questions and then answering them. And at paragraph 98 of his report, in the heading Fitness to Plead and to Stand Trial, again underlined, it reads, whether the appellant is fit to plead and stand trial. And although the Pritchard test was not mentioned in instructions, obviously Dr. Gupta was familiar with it, he can't, in my submission, be fairly criticised for explaining the real-world consequences of his clinical findings. Indeed, in my submission, it was part of his duty so to do. And the second point was the failure to consider the appellant's 4 affidavits sworn between the 30th of November 2022 and the 1st of February 2023, which he considered at paragraph 16.4. This is not a fair criticism of Dr. Gupta, because he was provided with 2 of the affidavits, and the weight he gave to them was a matter for his expert assessment. And he was entitled to rely on the results of his own objective testing of the appellant's mental state face-to-face, following a 4-hour face-to-face assessment, bearing in mind that his previous report was nothing like as long as that, the face-to-face. In fact, I don't think there was a face-to-face assessment. His subsequent report was clearly based on a much more full interview with the appellant. But in any case, the failure to make express mention of the two affidavits, or to have in his possession the other two affidavits, if that was important enough for the judge to consider it, so important, then he could have adjourned once again to give Dr. Gupta the opportunity to address them in a supplemental report, or indeed be cross-examined about them. Or once again, the authority of Solanki against Intercity Telecom Limited at the 2018 EWCA Civil 101 goes to that point. And if I can take your lordship to that authority at tab 14, which is at page
349.
my lord, 349, indeed. We see this. This was a case where a judge was wrong to refuse to adjourn a trial, again for non-attendance, where no sufficient reasons for disregarding the appellant's medical evidence indicating he was unfit to stand trial. Now, of course, in our case, reasons were given, but nonetheless, in my submission, the case is helpful. The appellant appealed against the refusal to adjourn his trial on health grounds, a refusal to set aside a judgment made against him, and a summary assessment of costs. Respondents brought proceedings against the appellant, their former employee, claiming he had used confidential customer information from their databases to solicit customers. The appellant gave undertakings backed by a penal notice. He admitted to contempts. A trial of the substantive claims was directed to begin on the 24th of February 2015, with the sanctions issued to be reserved for separate determination. On the 11th of February, the appellant was refused an adjournment to extend his legal aid order and to obtain new legal representation. On the 23rd of February, he sought an adjournment on health grounds. He attached a letter from his GP which stated he was suffering from severe depression with suicidal ideation and was medically unfit to represent himself in court. The application was refused, as was a further application made on the morning of the trial in which the appellant also sought to adduce new evidence. The trial proceeded in his absence. His defence and counterclaim was struck out for non-attendance and damages awarded against him. The appellant applied unsuccessfully to set the judgment aside, adduce new evidence, and vacate the sanctions. Costs was assessed summarily. The appellant submitted that the refusal of his application for an adjournment had breached his rights under Article 6, and the judge had erred in refusing to set aside the judgment under Rule 39.35. And the appeal was allowed. And in allowing it, the court, Lord Justice Gloucester and Lord Justice Singh, said that in reviewing the judge's exercise of discretion as to whether to grant an adjournment, the Court of Appeal had to be satisfied that a decision to refuse the adjournment was not unfair, particularly where the right to a fair trial was at stake, citing Berezovsky against Russian Television and Radio Broadcasting Company, 2010 EWCA Civil 1345, and Tainaz against Wandsworth, London Borough Council, which we have already seen. Overall fairness to both parties had to be considered, and the court said where medical evidence was deficient in some respect, a short adjournment might be appropriate in order to enable a litigant to make good the deficiency. And that was in ordinary civil proceedings. And as regards non-attendance, where there was a good reason, once again, as we've seen in other cases, that must be taken into consideration when granting an adjournment and to ensure the fairness of the trial. And if I could take your lordship to page 358, paragraph 32, the third sentence down. Rather, the authorities make clear that in reviewing the exercise of discretion, the Court of Appeal has to be satisfied that the decision was not unfair, For example, see Turlock against Berezovsky, 2010, EWCA Civil 1345 per Lord Justice Sedley, quoted below, particularly in circumstances where his right to a fair trial under Article 6 is at stake. And then he cites the passages from Tainaz, which your Lordship has already seen. And then over the page at page 359, at paragraph 35, which was the paragraph I wanted to originally draw your Lordship's attention to, two other points are worthy of mention. Obviously, overall fairness to both parties must be considered. Further, where medical evidence is produced which is deficient in some respect, it may, and they have italicized may, be appropriate to give consideration to a short adjournment in order to enable a litigant to make good such deficiency. If that applies in ordinary civil proceedings, in my submission, a fortiori, it must apply with greater force in civil contempt proceedings, to the extent that that may, arguably, should turn into a must. We've seen what the other authorities say in relation to that. Then, in addition, the important case of Newey against Griffiths, which is a 2023 case of the Supreme Court, UKSC 48, at the third volume of the Weekly Reports for 2023, 1204, says it's also unfair to reject evidence without cross-examination. And that is at tab 26, page 649. Very towards the end of the authority fund. Is, in my submission, an important case for your Lordships. In that case,
I don't want to stop you explaining the background, but I suspect we're broadly familiar with it.
familiar with that one. Very good, my lord.
I mean, the question which arises in relation to this case is what is said in that case appropriate not merely at trial, but in other circumstances, such as where, to take a case where there is existing authority, certainly at Court of Appeal level, where there is an application for an adjournment backed by some kind of medical evidence, does a judge have to accept the medical evidence at face value in the absence of cross-examination?
Indeed. Well, that even if that is an open question, it must apply in my submission in proceedings of this sort, i.e. quasi-criminal proceedings of civil contempt proceedings. And again, relying whether directly or indirectly on the cases cited, particularly they cite the case of Brown against Dunn, 1893, and that the general rule is that a party is required to challenge in cross-examination evidence of any witness of the opposing party. If he wishes to submit to the court, the evidence should not be accepted on that point. And the SRA certainly did submit that the evidence should not be accepted, and the court acceded to that in my submission wrongly. Whether or not it would apply in circumstances analogous if the proceedings had not been quasi-criminal proceedings is a question I don't need to answer, and may well arrive at a different conclusion. But in my submission, it is quite clearly the case where the liberty of the subject is an issue in proceedings that are, as we've seen, quasi-criminal. So that's how I would deal with that, my lord.
Yep.
If that helps the lordship. The third issue that the judge dealt with was that Dr. Gupta failed to set out reasons why the appellant was unfit to plead in Gupta 2 and had not contemplated this in Gupta 1. Well, very briefly, I've touched on that. Gupta 1 was based on a video link assessment carried out on the 27th of December 2022. Gupta 2 was based on a video link assessment on the 21st of September 2023, but also an in-person assessment of 4 hours. That explains the difference, and it's unfair to criticise Dr. Gupta for not seeing in Gupta 1 what became clear in Gupta 2. The fourth consideration was whether Dr. Gupta had applied the correct legal test, paragraphs 18 to 20 of the judgment. It's submitted that the Pritchard test, I've made this point numerous times, is the correct test to apply, and Dr. Gupta applied it. And if the appellant is right about that, then the judge's criticism falls away. But in the alternative, the 6 factors encompassed in the Pritchard test are, in my submission, also relevant to the test of capacity under the 2005 Act, which, as I've said before, focuses on whether a defendant can make a decision for himself. For example, instruct solicitor and counsel. See Section 2.1 of the Act. The fifth issue that the judge, the fifth reason he gave was inconsistencies between Gupta 1 and Gupta 2. And he identified 3 inconsistencies in approach between the reports. However, once again, they're all explicable in my submission on the basis of a more thorough investigation of the position for Gupta 2. And the same argument applies for the 6th. The inconsistencies between Gupta 2 and the 4 affidavits. And also the earlier points I made in relation to consideration of the 4 affidavits. And then he touched upon matters occurring after Dr. Gupta's assessment. And instead of using matters that occurred...
Just before you do, if we go back to the 4
affidavits.
So take, say, paragraph 23.
Of the judgment?
Of the judgment.
One moment, my lord. Yes, my lord.
I mean, paragraph 23, the judge says it's very difficult to see how Ms. Khan could have prepared...
Are we talking about the sanction judgment? Or the...
confidential schedule.
Oh, the confidential
sorry,
schedule.
yes.
Paragraph 23 of the confidential schedule, yes. Sorry, my lord, I interrupted you.
No, it helps if you have the right page, which I wasn't giving you. Very difficult to see how Ms. Khan could have prepared her 4 affidavits if she didn't have a clear and thorough understanding of the allegations of contempt and their severity, or if she could not instruct her solicitors or provide them with her views and opinions about the way to address these allegations, or provide them with any relevant evidence in her defence. Was the judge not entitled to take that into account?
It's entitled to take it into account, but again, this is going back to the question I was asked by my lord and answered in relation to the solicitor's letter found in the bundle between the 2 Chowdhury letters. Once I was asked, well, how can they say they took instructions and that they're following those instructions? The same thing applies here. It all depends on whether or not those instructions come from a source and a person whose mental capacity is not in question. Once that mental capacity is in question and once it's impugned, then those instructions take on a completely different signification. The best, and I've laboured the point about the difficulties that her legal representatives were labouring under, what they've got to do is take instructions because the judge has said she's capacitated, whilst faced with a report which, on the face of it, they consider to be sufficiently credible that they're coming to this court, as they did the court below, to argue that further medical evidence should have been obtained in order to be absolutely sure what the mental state of the appellant is. Faced with that difficulty, they have to make the best of the instructions that they are given. And those instructions may turn out to be less than coherent.
I mean, in the previous paragraph, the judge has said that he made a specific finding that Khan 1 to 4 betrayed a thorough understanding of the terms of the order and what compliance with it required. I mean, is that a fair comment?
Well, no, because the judge cannot come to that conclusion based upon what is in effect partial evidence, so partial in his mind that he simply dismisses it and bases his own judgment upon an assumption that what he sees to be a thorough understanding of the terms of the order, betrayed by 4 affidavits, that necessarily she must be capacitated. But of course those 4 affidavits have been compiled by her solicitors on instructions, doing the best they can, and I'm making the point that I made earlier again, assuming or not knowing whether those instructions come from somebody who has full mental capacity or not. And if she doesn't, or she's unfit to plead or unfit to give instructions, then those instructions might be virtually worthless. But that doesn't mean to say that she can't speak the English language, that she can't communicate something to her solicitors, and her solicitors can form the view this must be, or is the instruction so far as we're able to obtain them, and then on that basis to draft 4 affidavits, which she then signs. But if she's not mentally capacitated, those statements are worthless. And if she's not fit to plead or fit to give instructions or fit to provide evidence, they're equally worthless. So this is why I early said that what the judge has done is effectively beg the very question at issue. He's assumed the thing that's got to be proven, and which can only be proven by obtaining further medical evidence. Now, the medical evidence may well say, sorry, Dr. Gupta's got it completely wrong. Nothing wrong with this person. She perfectly well understands what's going on, and therefore the judgment, no doubt, the court will say, should stand. But we do not know until we receive that medical evidence. And until we receive that medical evidence, we only have a part, and the court only has, a partial view of what has really gone on in the mind of the appellant. And that must mean prejudice to the appellant and an unfair trial.
And I think I distracted you from where you were going next, which was
Well, I hope that was
subsequent evidence.
As far as he then deals with matters occurring after Dr. Gupta's assessment. This is in paragraph 24 to 26
Yes.
of the confidential schedule. Instead of using matters that occurred after Dr. Gupta's assessment to discredit Gupta too, the judge should have given Dr. Gupta the opportunity to address them, again, by further evidence, or indeed be cross-examined. And once again, I take your lordship back to paragraph 35 of Solanki. And again, it was unfair to condemn Dr. Gupta on the basis of matters he was not aware of, and or matters he had not been cross-examined on. And once again, the Supreme Court authority of Griffiths would seem to apply, paragraph 42. Then finally, he criticises what he says is a lack of reasoning to support the conclusion that the appellant could not instruct solicitors. And again, this is, in my submission, an unfair reading of Gupta too. Dr. Gupta's approach was to ascertain and diagnose the psychological impairments that the appellant was suffering from, and then simply to set out the consequences these had for her. And it was not necessary for Dr. Gupta to give further reasons. After all, he'd conducted a thorough assessment, administered objective tests of her mental state, and his central conclusion at paragraph 94 of his report was that there was a, quote, high possibility that her mental difficulties could have had an impact on her information processing and decision-making related to the issues mentioned in the very charges levelled at her.
Just pausing there, is high possibility enough to discharge the burden of proof?
That's only in relation to only one aspect of his report.
Yes.
It's more than a high possibility. He makes it completely plain and clear in relation to her fitness to plead, her fitness to stand trial, and so on. This is only in relation to the impact on her information processing that there's a high possibility. It's much more than that, as I say, in relation to the other parts of his report. And so, consequently, the appellant's case is that there was no fair trial, and that this constitutes a compelling reason within CPR 52 0.61b to set aside the judgment, in addition to the other points I have made. One might say the analogy is with cases such as where a non-English speaker is denied the services of a translator, or where, for example, a deaf person is not permitted to have proceedings translated into a sign language. And an example, for example, one might, if I take your lordship to the case of Rackham against National Health Professionals, which is a UKEA case at tab 12, which is page 297 of this is a case where the claimant suffered from Asperger's syndrome, and a judge decided at the second of 3 preliminary hearings that there should be a report from an expert, not a GP, as to the nature of his disability and adjustments. It will be reasonable to make to enable the participation in a 3rd preliminary hearing. The parties could not or would not fund it. Accordingly, the judge thought it proportionate to obtain the medical records of the claimant. They were provided. Parties then agreed between themselves what adjustments would be needed. At the hearing, an additional adjustment prompted by the Equal Treatment Bench Book, counsel for the respondent offered a written list of questions she intended to ask in cross-examination. Having failed to secure an amendment to the claimant then applied to answer the questions in writing and at home and sought a postponement to obtain an expert report on appropriate adjustments. The application was refused, and it was held the duty to make reasonable adjustments for the purpose of ensuring access to and participation in proceedings was undisputed. Was there an error of law in providing inadequate adjustments? To consider what an expert might say. Whatever approach was taken, whether assessing fairness, review, or hybrid proportional approach, as considered in the case of Daly, the court held there was no error of law here. The judge had considerable material on the basis of which he could conclude the adjustments proposed would be reasonable, so as to ensure the hearing was fair, which included the agreement of the parties. Claimant's agreement to the measures proposed should be respected since he had autonomy to make them. There was nothing to suggest the measures were inappropriate, and unfairness had to be judged by reference to both parties, to proportionality, and with a view to expedition in the judgment of the judge, if not conclusive, was entitled at the very least to considerable weight. And so there was no failure to follow the equal treatment.
Sorry, I'm a little puzzled. Can you explain the relevance of this authority? Because in the present case, we are not concerned with the question of reasonable adjustments. No. Your submission, which you've made very clear, is that your client was unable to participate in the proceedings at all.
Yes. I only draw your lordship's attention to this case for the benefit of paragraph 45, that's all. And it says in paragraph 45, it might be thought that in enabling a party who might not by reason of disability be able to participate adequately in a hearing, just as someone with limited language or comprehension might be unable, would therefore be an essential matter of fairness open to review on appeal. However, in this case, the decision would be bound up necessarily with consequential decision whether the case should be postponed to enable further inquiries to make.
This is
I think
all
that's
directed to
essentially
the
it.
question the court didn't decide, which was the intensity of review.
Yes. Yeah, indeed, my lord. But whether that authority is helpful to your lordship or not, in my submission, my point is that if there was there was no fair trial, and that in itself is a compelling reason, whether or not the analogies I've drawn are consonant or not. So, in all the circumstances, it's submitted that the court should follow in cases of this sort, the Pritchard criteria, or something very analogous to it. Not necessarily in place of the mental capacity rules, but in conjunction with them. And the judge was wrong not to apply that test, and to apply the 2005 test in a way that was prejudicial because there wasn't sufficient evidence to be able to deal with that. So moving on then to the other grounds of appeal, the finality principle, we say that the learned judge's approach to finality was wrong in law. The finality principle is not a relevant consideration when deciding whether a party is fit to stand trial, in my submission, and or plead, and or is capacitated.
Just seeing where we go on this, I mean, whatever view the judge took on that question, does it matter? Because the judge doesn't seem to rely on the finality principle.
That's true, my lord. I address it simply because it was raised, but I accept your lordship's point. He doesn't seem to have relied on it. So I'll move on. But there is another issue, and that is the judge's adverse inference warning.
Yes.
The court is obliged in law to give a warning that adverse inferences may be drawn from a party's failure to give evidence in contempt proceedings. Lordship may usefully go to Andreevich against Moutrey, 2020 WCA Civil at 382, which is at tab 18.
But again, before we get into the detail, does this point go anywhere either? Because the judge said he would reach the same conclusions anyway.
The judge?
The judge said he would reach the same conclusion anyway. So again, does this point go anywhere?
Yes, because it's a matter of procedural importance, regardless of what the judge ultimately decides, that an adverse warning must be given. And if it isn't given, that's of sufficient procedural importance to undermine the proceedings.
So can I be clear? Your submission is that if an adverse inference warning is not given, that undermines the proceedings, even if the court does not subsequently draw any adverse inference.
Well, as my understanding, that is the case in criminal proceedings. So it's simply a question of...
But of course, in criminal proceedings, you don't know what inference the jury has or has not drawn. So how can you draw a parallel?
My understanding is it applies whether there is a jury or not. That warning must be given. And if it isn't, that vitiates the proceedings. Now, your lordship's question is of course a fair one. Is that one of those aspects of criminal proceedings that carries over to civil contempt proceedings? Well, our submission is yes, it does. And the best I can do to assist the court is simply to draw attention to the words of Lord Justice Peter Jackson in the Andreevich case. And that's why I've suggested looking at that at tab 18. And I apologise if your lordship thinks it's off point, but it does seem to have some weight. Tab 18.
Page 419, I think.
At paragraph 16 and 17. Where Lord Justice Jackson, I hope I've got it right.
Yes.
Yes, I have this time. Starting points when striking the balance in this case is the duty upon a court hearing committal proceedings to ensure that the accused person is made aware that they are not obliged to give evidence and also warned that adverse consequences or inferences may arise from exercising the right to silence. Those messages may contain attention, but what matters is that the choice of how to proceed belongs to the litigant and not to the other party of the court. This is of particular importance when the litigant is unrepresented, and it does not apply any the less to the seasoned litigant in person or to the litigant who appears eager to enter the witness box. I therefore do not accept the argument that there was no procedural defect in what occurred in this case. I reject the submission that PA can be taken to have been informed of his rights by the reference to the rules in the skeleton argument. Even if that went some small way to informing him of where he stood, it was undone by the events at the hearing as prescribed in paragraph 5 above. Likewise, I cannot accept the description of this breach as being a purely technical one. The right to silence is a core element in criminal proceedings and proceedings of a criminal character. So what I read into that, rightly or wrongly, is...
Just before you go on, paragraph 18, Lord Justice Peter Jackson says, that being the case, the decision can only stand if we are satisfied that no injustice has been caused. So going back to my Lord's point, if the judge says, look, I didn't draw any adverse inference, would it not be the case that one could be satisfied that no injustice had been caused, regardless of anything else?
Just having a quick look at paragraph 18, if I may, Lord.
It's apparent from paragraph 18 that the defendant, who was not only a litigant in person and unrepresented, but who gave oral evidence and was cross-examined, and I can see that that's a very different sort of case, because it's quite difficult to say, well, I would have reached the judge would have reached the same decision even if you hadn't given any evidence at all, especially when at the end of paragraph 18, Lord Justice Peter Jackson says there can be no doubt that the judge's conclusions owed much to her assessment of his oral evidence. So in that case, one can see why he says this is not a mere technical defect, it might have made all the difference. That's not quite the position we're in here, because Ms. Khan chose not to give evidence, and the judge said, I would have reached the same conclusion even without the inferences, which in fact I think can be drawn.
Lord, I take your Lordship's point. But my understanding is that it is a sufficiently serious procedural defect in criminal proceedings to vitiate those proceedings. And the question, therefore, is, should that consideration carry over to civil contempt proceedings?
I think, I mean, not tonight, but you've made the point that you think that that applies even where there is no jury. Well, I suppose if there were no jury, in normal circumstances, it would be magistrates. And they don't give full reasons either, do they?
They don't
give full reasons either,
no.
Do they? So it's rather different from where you have a full judgment from a judge and he says, I'm not drawing the inference.
So I'm not sure I understood your answer to Lord Justice Nugee's question, because what he asked you was this, rephrasing it in my own words. He said that in the Andreevich case, it is clear that Mr. Andreevich's rights were infringed because he was not warned that he had a right to remain silent.
Yes.
And because he was not warned that he had a right to remain silent, he gave evidence and the evidence was held against him.
Yes.
So he was plainly deprived of his right to silence.
Yes.
Whereas, my Lord put to you, isn't this not the converse case? Because your complaint is that Ms. Khan was not told that she had a right to remain silent, but she did remain silent. So in what way was she deprived of her right?
And I've accepted my Lord's point.
Okay.
As I have to. And I've fallen back on my primary submission, which was, well, it vitiates criminal proceedings, regardless of whether the circumstances are the same as here or not. Does that carry over to civil contempt proceedings? Is an open question. I'm urging upon your lordships that it should. Miller and Fred will no doubt say the opposite.
And just,
and I can't
definitely not for tonight. If you were able to provide us with authority showing that the rule applies even in relation to criminal cases where there is no jury, I would be interested to see it.
Yes, and I've had to accept that as well, because, as your lordship says, it's unusual for magistrates to give reasons.
I mean, I follow that, but I would still be interested to see the authority dealing with that sort of situation.
And my problem is that I haven't been able to find one.
Oh, I see.
So that's why all I can do is make
Yes,
that
I see.
submission.
Yes.
And that's-
I think I would quite like to see how it's put in the textbooks, Archbold, presumably, in criminal proceedings.
Yes. Indeed.
Not necessarily any authority, but just the statement of the importance of the principle and what the consequences are of not
Indeed.
complying with it.
Indeed, and that I will also do the same. If I failed first time round, if I perhaps look a bit harder, I might find something. But just moving on then from that, what the judge says at paragraph 32 of his liability judgment is that the judge indicated he was reluctant to accept the SRA submission that the appellant had chosen not to give evidence because she recognised she could not exonerate herself and that cross-examination would damage her case, because the classic position, as he put it, was that an inference of guilt could be drawn from a decision to exercise the right to silence. And he was persuaded to accept that submission, following my Lord's judgment again, in Business Mortgage Finance 4 PLC against Hussain, 2022 EWCA Civil 1264, at paragraph 112, and that's at tab 23 of the bundle, authorities bundle, which is page 560, where my Lord said the remaining point taken by Mr. Counsel was that Mr. Justice Miles was wrong to conclude that Mr. Hussain's silence could only sensibly be attributed to his having no answer. The claimants having failed to establish a case sufficiently compelling to call for an answer. I do not think there is anything in this point. The claimants had, in my view, plainly done enough to establish a sufficient case to answer. Mr. Hussain chose not to give evidence. He was not obliged to, but the necessary consequence is that Mr. Justice Miles did not have the benefit of any explanation from him. What Mr. Justice Miles said, at para 311, is this: the features highlighted above clearly call for an explanation. Mr. Hussain has, without good reason, chosen not to attend the trial. He's also chosen not to give evidence. It is his right to remain silent, but I infer that he's chosen not to give evidence because he recognises that he's unable to give exonerating evidence and that cross-examination would further damage his case. This supports and strengthens the conclusions I've already stated. And my Lord goes on, in my judgment, that was a view Mr. Justice Miles was entitled to come to. In any event, as he says, it only strengthened the conclusion he had already come to on other evidence. However, I say this in relation to Hussain. My Lord was dealing with a separate point, namely whether on the facts of the case, Mr. Justice Miles was entitled to draw inferences from the defendant's silence. Those comments were fact-specific. They do not meet the appellant's point here that the court in the present case should have given a warning of the consequences. That point wasn't at issue in Hussain. And I think, well, I'm not sure I can take that point any further in light of what the exchange that I've had with your Lordship. But I simply say that it's a different situation from the present.
Do you suggest that what I said in Hussain was wrong and in ignorance of prior authority?
No.
No.
I simply say it's fact-specific and
Yes.
distinguishable on that basis alone. What I would say is that in relation to paragraph 123 of the liability judgment, where the judge states he'd not found it necessary to rely on any inference drawn from the failure of the defendant to give evidence, that is, with great respect to his Lordship, a little difficult to credit, given that he does appear to have drawn inferences. And so, in those circumstances, if that is right, well then, of course, the procedural safeguard begins to assume a slightly more important significance. And of course, the court shouldn't speculate on what might have happened had she given evidence. That isn't material. And in support of my submission that the civil court should follow the same approach as the criminal courts, again, parce what your lordship has said about juries, in the case of ADM International, SARL against Grainhouse International SA, 2024, EWCA Civ 33, at paragraph 51, which is at tab 27, page 671 is the beginning of that case. The court says that the approach is an inference from failure to give evidence cannot on its own prove guilt. And secondly, the court must be satisfied that the judgment creditor has established a case sufficiently compelling to call for an answer before drawing any inference from silence. And if it concluded that silence could only sensibly be attributed to the defendant having no answer, or none that could stand up to cross-examination, the court then could draw an adverse inference. In short...
What paragraph was that, sorry?
That was paragraph 51. So, in short,
Maybe
subject
Michael,
to
I'm
caveat...
struggling to find that in that paragraph.
I'm sorry, my lord?
I may be misreading, but I'm struggling to find
I'm sorry, I've got it wrong.
what you were citing in that paragraph.
Is it 671? 680. Yes, sorry, 680, my lord. 680 under the heading the appeal of the law.
Yes. There's nothing there
wait a
about
minute.
silence or drawing inferences.
Yes, I appear to have taken your lordship to the wrong reference.
I think that Mr Justice Christopher Clark said something about it in Masri,
Yes.
which is quite a long judgment.
Yes, you're right, my lord.
Try
51.
147 of
Masri.
Masri on page 229.
Thank you, my lord. Yes, thank you very much, my lord. That's it. I apologise, my lord.
I think that's very similar to what Mr Justice Miles did in Hussein's case and what I said he was entitled to do. What if you can't just say you haven't given evidence, so I'm going to assume you're guilty, infer you're guilty. But you can say, here's compelling evidence on one side. You haven't given any other evidence, so I don't have anything to set against that. And I can therefore infer the reason you haven't given evidence is because you don't have anything you can say.
Indeed. Accept. Indeed. Thank you, my lord. Now, my learned friend made reference before the short adjournment to his concern about two issues. I don't understand the first one. He was, I think, saying that we were going beyond the grounds of appeal or beyond our skeleton. I'm sure he'll explain that. But he's right in relation to the supplemental skeleton. There is what looks like a new ground, and it may be that I have to either abandon it or ask your lordships to grant permission for that to be added. What I will do, if I may, is make those submissions on them on the ground being made good in due course, if your lordship will allow.
So
It relates to the late skeleton argument, which was, I think, delivered on Monday at some stage.
this is the consolidated supplemental skeleton.
That's right,
Yes.
If I make those submissions,
And sorry, which submission? This is the additional submissions in 14.
it's only in relation to the deployment of evidence point, which I think is the very last couple of paragraphs.
Paragraphs 14 to 16 at the end.
Well, before this point is raised, I should say there is another issue, which is there is no permission for a supplemental skeleton argument. And the practice direction makes it clear that, firstly, permission is required, and secondly, it would only very sparingly be given if raised within a week of the hearing. Now, well, it's a short point, and it's something I think I have a comprehensive answer to without any prejudice, but that application ought to be made as well, or at least considered by the court.
Yes, I follow all that. I think, I mean, in the first place, if the point is going to be made, it's quite convenient to have it in writing. That doesn't mean that we have to entertain it, but I think it's convenient to hear Mr. Bogle make the point, and then we can decide what to do about it.
I have no objection to that, my lord, and I agree it is convenient to have it in writing. But on the record,
Yes.
it's not something we've consented to go.
Yes.
Right, thank you, my lord. The appellant, as your lordship knows, gave no oral evidence in the course of the committal trial, but as you saw, did file and serve 4 affidavits which were considered by the court. So an additional issue which arises for the court from consideration of a decision of this court in Turner and another against Coates, 2023, EWCA Civil 1487, and to paragraphs 13 to 16 of the liability judgment, as to the evidential basis of the affidavits filed and served by the appellant prior to the contempt hearing.
Well, can I just clarify one thing which may or may not be important? In your supplemental skeleton argument, you refer to the documents in question as being statements, which I would normally think to mean witness statements. But am I right in understanding that in fact what you're talking about is, as you've just said, affidavits?
Yes, my lord.
And would you accept that affidavits stand in a different position to witness statements because they carry, to use the old Latin tag, jurats?
Yes.
That is to say, they carry oaths. They don't need an oath to prove them.
Indeed.
So are you in a position to say that affidavits sworn in opposition to contempt applications are inadmissible?
If no, ordinarily, but the situation may be different where we have a litigant, an appellant, whose mental capacity of fitness is in question.
Well,
that may...
that's a separate issue.
It is a separate
If you're right on fitness,
Yes.
none of this arises.
None of it, yes, that's true.
So we have to assume for this purpose you're wrong on fitness.
Very good, my lord.
Can I just understand where the thrust of the point? So what is it you say the judge should not have done?
Well, Parche, my lord's point, which on the face of it appears decisive. What I was going to say is that, and this was an issue that arose because the judge said, all right, if you're not going to give evidence, are you deploying these affidavits? He was asked. I mean, that tends to
before
suggest...
Mr Justice Leech,
That was right.
he asked whether the
Yes, he
affidavits were being deployed.
And we answered yes. But on my lord's point, that isn't necessary because the affidavit stands on its own 2 feet because of the jurat.
But so the judge specifically asked whether the affidavits were being deployed.
Yes. That's right. But that's what. Yes, we were asked. But
So sorry.
no, what we said. Sorry.
If you're saying that if you tell the judge they are being relied on, he was entitled to rely on them, presumably.
Well, on the face of it, yes. But for the case of Turner and Coates, leaving aside
where I was a member of the court, and I have to admit I don't remember any point that would bear on this particular issue. But perhaps we should have a look at it.
What it appears to say. Well, the issue isn't to.
Do we have it? Do we have a copy of it?
No, you don't. But
You don't.
I would like to give your lordship a copy.
Yes.
At this stage, I'm only making the point.
Just before we get into the authority, can we just stand back a moment and look at normal procedure? So, the normal procedure on a committal application is that the respondent to the application is under no obligation to serve any evidence whatsoever.
Indeed.
So the respondent is fully entitled to say, I'm not going to serve any evidence in answer to this application because I have no case to answer.
Indeed.
And moreover, you can't draw any inference from my silence. However, would you dispute that as soon as the respondent chooses to serve an affidavit in response and serves that affidavit, the affidavit is then in the proceedings and can be relied upon by the applicant?
What we say about if it were a witness statement, no, according on the authority. Not well. Coates is not,
that's why I was concentrating on affidavits.
Of course, I fully take your lordship's point, and on the face of it, it appears to be decisive.
Right.
But what we are saying is that in Coates, the court wasn't required to make a decision, but raised the issue as being one that is an open question. And therefore we were going to submit that as an open question, we invite your lordship to consider that, in fact, if they were witness statements, they had not been deployed because they had not been verified in the witness box. And it seems, Coates seems to suggest that that is a principle which it declines to determine, but which is open nonetheless. But my Lord's point would seem to address the issue to the extent that it's different when there's a jury.
If you have copies of Turner and Coates with you, perhaps we should look at it to understand. I realise how little I remember of what was said not very long ago.
In particular, it's a very short passage, and it's at page 4, paragraph 13 of the judgment. On ground 4, Mr. Colville argues that a defendant has the right to remain silent, cannot be compelled to give evidence. Exactly what my Lord has just said, in short, citing CPR 81. Mr. Coates appears a litigant person, chose not to give evidence. The witness statements, earlier prepared, ought to have been excluded from the proceedings. The judge erred by failing to do so and by taking those statements into account. Paragraph 14, last sentence. However, and this is at Comet Products against Hawkins.
Should we just read what paragraph 14 does say? I mean, on the face of it, possibly, without getting properly back into it, there are two ideas. One is, has the evidence been deployed? The other is it evidence at all because it hasn't been verified? Now, in this case, it has been verified because there's an affidavit. And secondly, you were asked whether you were deploying it, and you said you were. So I'm not quite sure where all this takes.
That's my Lord's point, and of course, as I've said. Now,
Yes.
I've just been pointed to an authority called Deutsche Bank against Sebastian. I don't have copies of it here. Paragraph 52 of which appears to suggest that even an affidavit is not adduced.
I quite followed that point, but then that's why the judge asked you whether you were relying on this material, and you said you were. So it is deployed.
So, but also there's the separate question which is touched on in the Ward's case, which is whether you expose yourself to cross-examination, and you need to distinguish between where the respondent has sworn an affidavit, that the respondent doesn't thereby expose him or herself to cross-examination unless the respondent continues to rely upon it. But that's a different question from whether the applicant can rely upon the affidavit.
I take your Lordship's point. Can I reserve my position on this? It may be that this, particularly as it comes rather late in the proceedings, for the reasons my learned friend said, and revisit it with the proper application if we decide to pursue it in due course. That, it would seem to me, my Lord, is the best way to deal with this point. And if there are other authorities that are relevant and will assist the court, then obviously we'll provide those. So, as I said at the beginning of my remarks, the thrust of the appeal really, in essence, despite all of these side arguments that we've just had, is in fact relatively straightforward. The bottom line, as I said, is simply, and forgive me for repeating myself, I want to reorientate back to the simplicity of the essential part of the appeal. Neither the parties, nor their legal representative, nor even the court, are qualified to make a medical determination about the appellant's mental state. That requires medical evidence, further medical evidence, the present medical evidence being inadequate, according to the judge, from a properly qualified medical practitioner. The court cannot properly make a legal and general determination as to the appellant's mental state, in my submission, without that evidence. Mr Justice Leech couldn't do so, and this court, in my submission, cannot do so. Anything less than full and proper medical evidence about her mental state will necessarily, in my submission, be unfair to the appellant and is likely to result in injustice, all the more so given the nature of these proceedings and the liberty of the subject. Moreover, the judge himself will be hampered in his ability to get at the true facts in relation to the appellant's mental state and to reach a proper decision without that full and proper medical evidence. After all, the medical evidence may say that, in fact, her mental state is sufficient for her, for the judgment to stand. But at the moment, the evidence being partial, we cannot be sure of that. And so, in my submission, the judge made an error by proceeding without taking those steps, which he was invited to do, as we've seen. Furthermore, both the court and the parties will need to know from what date the appellant's mental state became a real issue. That is particularly so in this case. As I said, there have been a plethora of applications. So it was crucial for the court to have that full and proper medical evidence, to be able to determine what was, as I said, literally a show-stopping issue before proceeding any further. And the judge, in failing to do so, both in the first contempt proceedings and the second contempt proceedings, made, in our submission, a serious error of law. And that, in simple terms, is the primary gravamen of the appellant's case. In those circumstances, in the premises, the court is asked to set aside the committal order altogether, and, if it be not an abusive process, to order a rehearing following the obtaining of that further evidence as to fitness and capacity, and a determination of that issue, if necessary, with directions by that judge for that evidence to be filed, and if necessary, with cross-examination, so that the issue of fitness to plead and capacity, and even if fitness to plead is not the appropriate test under Pritchard, certainly capacity is, and there is no evidence before the court upon which the court could make the determination which he did make, apart from the evidence of the appellant, which in my submission is insufficient. Medical evidence was required, and therefore on that basis the order should be set aside and those directions given. My Lord, unless I can assist you further, those are my submissions.
given that rousing peroration, may I just ask you this question? What do you say, if anything, we should draw from the fact that your client is today present in court and, as we have seen, able to give you instructions?
Well, do we know the extent to which he's able to give instructions? It's exactly the same point that your lordship made in relation to the letter from Jane's solicitors. It's exactly the same point that my lord made in relation to other issues of where the judge himself said that there was clear evidence she was able to give instructions. The judge is not in a position to be able to determine that issue without medical evidence. I'm not able to, and with the greatest respect, neither are your lordship.
I'm sorry, I'm baffled by that answer. Forgive me if I'm misunderstanding, but at various points during the hearing, you have turned around and sought instructions from your client.
Yes.
And she has given you instructions.
Well, mediated through my instructing solicitor.
All right.
But what purport to be instructions have certainly been given. And indeed, as I said, the 4 affidavits could not have been produced without something approximating to instructions. But the extent to which those instructions are genuinely instructions can only be determined if we know from medical evidence what is the true nature of her mental state. It may well be that medical evidence says, yes, she is perfectly able to give instructions, but we have Gupta too that says she isn't.
I rather suspect that the point you're making shades naturally into what comes next, which I think is the SRA's application to admit further evidence, which is sort of along the same lines.
Yes.
Yes,
is that where we
no doubt your answer will be the same. Yes.
Yes. Is that where we should go next?
My lord, yes.
I think we might as well make a start on it at least if
Very good,
you've
my lord.
completed your submissions.
Very good, my lord.
Mr. Alquist.
Thank you, Lord. I was going to suggest the same because as matters transpire, I think I can take the oral submissions on this quite shortly. Essentially, as a result of what my Lord Justice Arnold has just said, at the time that this application was filed, when we served our skeleton argument in the main appeal, the direction listing these 3 appeals together had not been made. One of the points of concern, if I can put it like that, therefore, was that on the one hand we had Ms. Khan, on behalf of JFP, acting for Ms. Khan, corresponding with the court, filing documents in the what I'm going to call the 2022 appeal. That is the appeal for which my Lord Justice Newey has refused an extension of time, and there's a reconsideration set-aside application listed for later on in this hearing. We had extensive correspondence on that. We had the slip rule application that Ms. Khan made to Mr. Justice Leech in July 2023 and argued herself in person against me for a half-day hearing. And we had the proceedings before Mr. Justice Lavender, for which the court has now seen the judgment. And there are various other points, but the key introductory point, my lords, is that all of that now is before the court on one or other of the procedural applications that is before the court at this hearing. And so our application to rely on the fresh evidence, as far as that information is before the court, really just goes to the point that my Lord Justice Arnold raised.
Yes, but can I be clear? I mean, I understand on one level the point you're making, but just because we have 3 different matters before us, and therefore we are in possession of all the documents, doesn't in and of itself lead to the conclusion that evidence in one matter is automatically an evidence in another matter, does it?
No, it doesn't, my lord. That's absolutely right, and that's why I'm still making the application.
Yeah, or informally speaking, you still need to do it.
Yes, and I'm outlining it. But where I had intended to go was to have to take you through the evidence, show you what all of it was, explain what Mr Khan has been doing, and the numerous applications that have been made to Lord Justice Newey and so forth.
I mean,
I'm conscious the court will have read.
My brethren will tell me otherwise. My impression is that we have a general idea of what is in this file, having looked at it on a de bene basis. How I suspect we'll proceed in the end, having heard you on whether we should admit the material and having heard Mr Bogle on whether we should admit the material, is that for the rest of this hearing, we will allow it to be referred to on a de bene basis. But sooner or later, we have to decide formally whether to admit it. What I think might be helpful, to the extent there's any time tonight and in any event tomorrow morning, is first, if you could just take us to what you say are the highlights. Not go through the whole bundle, but a few highlights. And secondly, obviously, explain why you say we should be admitting this material at this stage.
Certainly, my lord, I can do that. I may take them, if only for time practicalities, in the opposite order, and deal with the basis on which we make the application and its relevance now.
Yes.
And then perhaps in the morning I can more concisely go through the highlights.
Yes.
Which will effectively then remove the need for me to do so in main submissions on the appeal. We've cited, in terms of jurisdiction, my lords, this court will not need reminding that, generally speaking, an appeal is determined only on the basis of the evidence before the court at first instance. There is, however, in the CPR, provision for fresh evidence to be admitted. The reference, I think, my lords, to start with, I'm going to go to the White Book and then turn to the authority we have in the authorities file. CPR 5221.2 is the relevant provision, and that is in the White Book at page 1800. As we know, my lords, it says, unless it orders otherwise, the appeal court will not receive oral evidence or evidence which was not before the lower court. Now, the most well-known of the authorities on this is, of course, Ladd and Marshall. And on some of the other applications to adduce additional evidence in support of the other appeals, we may need to go to Ladd or consider Ladd and Marshall. But that is not, it's well established, that is not the test under the CPR. And if I can turn in the White Book at the foot of 1803, just to give the context of the authority I'm about to turn to, we have the well-known judgment from Lord Phillips, Master of the Rolls, as he then was, in Hamilton and Al Fayed, 2001. And the key paragraph is there, quoted in 5221.3 of the commentary. Starting the second sentence of that quotation, in a case such as this, which is governed by the transitional provisions, as they would apply under the CPR, we do not consider that we are placed in the straitjacket of previous authority when considering whether such special grounds have been demonstrated. That question must be considered in light of the overriding objective of the new CPR. The old cases will nonetheless remain powerful persuasive authority, for they illustrate the attempts of the courts to strike a fair balance. So the test, and the quotation concludes, that task is one which accords with the overriding objective. Now, my lords, the Ladd and Marshall test famously asks the question, could the evidence have been adduced with reasonable diligence at the hearing before the judge below? That is not apt, obviously, to deal with the situation where the evidence in question concerns subsequent developments.
Well, in one sense, it's apt because plainly it couldn't have been adduced with reasonable diligence below.
Well, yes, but perhaps then it doesn't assist.
Yes.
It doesn't assist in the determination of whether it should be admitted or not. But there's guidance, summary of the case law on this, at the top of page 1805, introduces the authority I'm going to come to. It says, this is the end of the same subparagraph of commentary at the top of 1805, Rule 5121.2, unlike its predecessor, contains no qualification concerning matters which have occurred after the date of the trial or hearing, under the formal law, the express but exceptional power to admit further evidence as to matters occurring after the date of the trial or hearing was exercised sparingly and with due regard to the need for finality in litigation. A number of Hughes and Singh times is there been cited. The position of the CPR was summarised in the Crown on the application of Iran against Secretary of State for the Home Department at 34 to 37. It remains the case that evidence of changed circumstances since the date of the original decision should only be admitted, sparingly admitted. Examples of the cases in which it was appropriate to admit such evidence were given by Lord Justice Brooke at 34. My Lords, we have the decision in the Iran case in tab 9 of the authorities bundle, which is page 120. And the circumstances of that case were somewhat unusual and complicated. There were in fact 5 different appeals all listed before the court. And they ultimately concerned the jurisdiction of the former Immigration Appeals Tribunal to deal with evidence showing that an original decision was wrong. The factual context of the case, really, my Lords, is neither here nor there in the statement of principle that one finds in Lord Justice Brooke's judgment. And that starts at page 138 of the authorities bundle, paragraph 34. And there are a number of examples set out at 34 of changes in one is a change in circumstances after the granting of an injunction.
Is this on the same point that we're about? Because, as I understand it, what he's talking about here is where something in the circumstances of the litigation has changed. Whereas what we're talking about is evidence directed to an issue at the hearing, but the evidence appears later. That's different, isn't it?
It is, my Lord. I wanted to take us to 34 to show the nature of the points for which there is authority, because I haven't been able to find any authority on a situation where it's said that someone is incapable of conducting litigation, but then they continue to do so. And the point, my Lords, is that there is a change in, we say ultimately it's a continuation of the evidence which the learned judge accepted in the confidential schedule, as I'll turn to tomorrow. I wonder, my Lords, if it's easier if I put the answer to the question the other way and come at it from another direction, and to say this: our ultimate submission on why this should be admitted under the overriding objective, leaving aside the analogies with previous cases and so on, is that it would be bizarre in our submission and contrary to the overriding objective for this court to consider that on the evidence as at the 8th of March, there was an issue as to whether Ms. Khan could actually conduct litigation in the contempt proceedings, when all the evidence in the subsequent year, including, as my Lord mentioned, the evidence of what the court has witnessed today, shows the contrary. And essentially, my Lord, our submission is that the learned judge was right to say that on the full picture of the evidence, including what he'd seen in the conduct of the litigation before him, he was not satisfied that Ms. Khan lacked the capacity, because he could see plainly that she did.
Could see what?
Plainly that she did have the capacity from her steps in the proceedings. And we say, my Lords, that this court can and should admit the evidence of Ms. Khan continuing to conduct the litigation and demonstrate her capacity in the same way.
So essentially, we don't need to look at any more authority. Your submission is that in a post-CPR world, in this type of case, we're not strictly tied to London Marshall. We should look at matters on a somewhat different basis. And while you may not have found authority dealing with quite this situation, it's on the facts appropriate to let it in.
Yes, my lord. And the one point I might go to back in Iran is the point taken in 34.4.
Should we just look at that?
And I accept this is only an analogy and a fairly remote one. From time to time, it's admitted on the basis that the court should not speculate where it knows damages will be assessed on the facts as they appear at the date of the appeal hearing. Now, I'm not sure the syntax of that is entirely correct. One usually would say that the court should not speculate on what it knows.
No, it is, should not speculate where it knows.
Oh, where it knows. Yes, my lord is correct. Should not speculate where it knows, and what it is dependent. So, to bring that back round to the same point, my learned friend has said several times today, well, it would be interesting to see what Gupta 3 would have said if the judge had granted permission for an adjournment of it. But this court has even more evidence.
But it's a different point, isn't it? Because what Iran is talking about in that example is take someone where someone is ill at the date of trial, and subsequently, by the time you've got to the Court of Appeal, the person's died. Now, it's a subsequent change of circumstances. It was something that might have been contemplated at the date of trial, but wasn't known, so it would have been a matter of speculation. By the time you get to the Court of Appeal, you know the person's died, and the court doesn't shut its eyes to that. But that's why it's a change in circumstances. Whereas what we're talking about here is not a change of circumstances, it's later evidence, which, because it's later, was not available at the hearing, but you say it is evidence to prove what you were trying to prove at the hearing.
Yes, my lord, we do. And it may be that the analogy is limited that far, and my Lord Justice Newey is right, we don't really need to look at the authorities. But I do maintain the position that you say it would be wrong under the overriding objective for this court to shut its eyes to what it knows now, given that there is no evidence of any change in circumstances.
One thing we did see in the passage in the White Book, which you took as, was reference to admitting evidence sparingly. Do you quarrel with that idea?
No, my lord, I don't. This was the last point I was going to come to, really. On the question of sparing admission of evidence, the finality of litigation, the purpose of that is clear, that the appeal court shouldn't start trying to have a lot of extra evidence, subsequent developments, and therefore having to redo the whole trial. There are clear case management issues, clear problems with that in terms of the allocation of judicial resource. But here, as I said when I started, my lord, we've got almost all of the evidence. Certainly, all of the key evidence is within the purview of the appeal bundles already. There are some other points around television appearances and metadata of documents, but I think it's clear from those are not irrelevant, but they're certainly of secondary importance in comparison to the actual conduct of hearings. Attending hearings and actually giving instructions to counsel, or indeed arguing hearings and corresponding to the court.
Is that going to be a convenient moment to...
I think it is, my lord. I will go through some of the highlights tomorrow, but I can do so quite briefly, and then either my learned friend will speak, or I'll just go on to the main appeal, whichever is more convenient.
10:30 in the morning.
All right.